Welcome to the Don't Sign That Contract Yet, a webinar brought to you by AIA Contract Documents. Thank you for joining us today. We're going to do a few housekeeping items before we get started. The first is the disclaimer here. This program and accompanying materials and any program by AIA Contract Documents is for informational purposes only. It is not provided as legal advice. This program is registered with the AIA for one learning unit. When you registered for the program, you entered your AIA member ID, if applicable, and we'll use that information to report your credit within 2 weeks of the conclusion of the program. We'll also be emailing you the PowerPoint along with the recording of today's program by tomorrow close of business, so look out for that. And you will also find this program and others uploaded to our Learn page on our website. Lastly, in regards to questions, we do have all attendees currently muted. So if you have any questions, please enter them in the chat. We'll try to get through as many questions as we can by the conclusion of the program. So now I'm going to go ahead and introduce briefly our presenters before turning it over to start our program. Our presenters for today are Jimmy Germano, Esquire. Jimmy is an attorney that works in the AIA Contract Documents. He's a senior manager and counsel working on our content. We also have Sarah Bauer. She's also an attorney on our team, working as a manager and counsel with AIA Contract Documents content. And lastly, we have Mike Koger. He is both an architect and an attorney working with AIA Contract Documents for a decade now, and he is senior director and counsel. So with that, I'm going to go ahead and turn it over to Mike Koger to begin. Mike?
Awesome. Thank you, Hasti. And thank you, everyone, for joining us on this webinar. In this program, we're going to be talking about our top 5 signs that you're about to sign an unfair construction contract. This list includes a few specific provisions that you should be looking out for when you're reviewing construction contracts. We've also got a handful of negotiating tactics that we want to let you know about that should be viewed with a heavy dose of skepticism. And I should also say that while we're calling this a top 5 list, that's not a real number. That's actually a bit of a lie. We couldn't help ourselves. We actually turned this into a top 7 or 8. And we've also got a bunch of honorable mentions at the back end of the program. So realistically, I think we probably list off at least 12 or 13, maybe 15 things that you should be looking out for. But we've kind of put these in, at least some order where we give most weight to the top 5 or 7 or so that we're going to talk about first. Then we'll rip through the honorable mentions in a pretty quick fashion at the end. A couple other things to note before we get into the list. First, while we are going to be talking about and referencing AIA contract documents throughout this program is not solely going to be focused on any particular AIA contract document or family of contracts. Instead, what we're going to do is focus on issues that we've each come across in our time as practicing attorneys before working with AIA contract documents. And these are going to be things that kind of always stood out to us during the contract negotiation process as being red flags in some way. And lastly, before I get into the list, I have to say that, we're going to inevitably label things as being unfair or as a red flag or something that you should focus on and scrutinize more heavily. Just know that there's probably exceptions to every rule. So, when we label something as, well, that probably is unfair, just know there's always going to be an exception, to any rule. So just keep that in mind. And with that, let's get into our list. Okay, so the first red flag we have to talk about are pressure tactics. And this is a pretty, common feature of the contract negotiation process. It's when one side attempts to apply pressure to the negotiating process to set up a power imbalance of some sort, or to hurry you into signing something against your interests. This is, these kinds of pressure tactics can really come up in many forms, but I've included some of the most common ones that you'll see on this screen. This is not at all unique to construction contracts. You've ever bought a car, you've leased an apartment, you bought a timeshare, you're familiar with these pressure tactics, one way or the other. You've probably seen them outside of construction contracting and also when you're negotiating construction contracts as well. The most common way, pressure tactic that I've seen is when one side sets a quick deadline for you to make a decision and sign a contract. And when you're confronted with a quick deadline, which happens pretty regularly, I think you really need to just take a step back, take a deep breath, and try to determine whether there is a real need to rush into a contract or whether the other side is posturing a little bit. My solution, the way I solve this issue when I get somebody who is putting a quick deadline to me is I always try to negotiate the deadline first and then work on negotiating the problematic terms in the agreement. I do not try to, negotiate both at the same time. If you're trying to negotiate an indemnity provision or liquidated damages at the same time you're trying to negotiate a very quick deadline, you are really playing into that pressure tactic. And so, first thing first, if someone's asking you to sign right here and now or sign something in 24 hours, you need to be asking follow-up questions. Why do you need me to sign something that quickly? What are your real deadline requirements? Is there a real deadline or is this a fake deadline that you're kind of pushing me into? So if someone's asking you to sign something right now, ask them, why can you give me 72 hours? Is there a real reason that you can't give me 72 hours? Another pressure tactic, which is a little bit less overt than a quick deadline, is what I'll call the it's our standard agreement approach. This is when an owner or contractor gives you their company's preferred contract and effectively tells you that they can't or will not deviate from it. You'll hear everything from, don't worry about it, everyone just signs this contract as is, to it's my company's policy not to deviate from this form, or I have to send it to a attorney or to our legal department to review any changes. And some of that might absolutely be true. However, just keep this in mind. One thing I can guarantee is that the standard form you're receiving was 100% drafted to favor the company that produced it and to shift risk to you in these kinds of situations. Now, that is, unless, of course, you're being given an AIA contract document, which a little bit of shameless advertising for AIA contract documents. We do draft them to be fair to all parties. But if you're getting something that is an agreement that was created by an owner, and they're just telling you just sign it, we don't need any edits, we don't accept edits, it probably is going to be against your interest as a contractor. So you need to review it closely. And I would also suggest that it's a truism of construction and of just business in general that if someone wants to do business with you, they will allow you to negotiate the terms of an agreement within the bounds of reasonableness. So my solution to this issue is do your own review, make your own judgments, about whether or not a contract is fair. And you might actually need to find another person to talk to who has authority to negotiate the agreement. So if you're talking to a representative of an owner or of a construction company and they say, we can't negotiate anything, we'll say, well, find me someone who can. Find me an attorney, on the general counsel who can listen to my concerns and maybe negotiate with me a little bit. And the last kind of pressure tactic, that I'll identify here is when you identify a justifiable concern and the other party is just completely unwilling to acknowledge the validity of your concern or to make an appropriate adjustment. So, for example, if you're a contractor, an owner hands you an agreement and it has a risk in that contract that you've identified as, I just can't get insurance for that. That's a very, understandable concern. And if the other party just says, nope, not gonna make an adjustment so that you can get insurance for this risk that you're taking on, you need to really hold your ground in those instances and again, elevate it to a general counsel, someone at their office who can negotiate with you. And also keep in mind with any of these kind of pressure tactics, there are always worse things than walking away from a contract. So if you cannot negotiate a fair contract that, allocates risk fairly, it might be a good sign to walk away from the deal. And you'll be impressed with how often walking away or threatening to walk away will actually get you more negotiating leverage. Okay, I also want to touch on two other provisions that will often appear in construction contracts that you need to pay close attention to when a pressure tactic is being applied to you. One is an acknowledgement that both parties had an opportunity to consult with an attorney. The other is a provision where the parties agree that the contract will not be construed against the party who drafted it. And I want to stress that there's nothing inherently wrong with these provisions in and of themselves. You will see them in a lot of contracts. There's really nothing wrong with them. but do understand that when they come up and when they are combined with pressure tactics, they can become problematic. And that's because the entire reason that these are in a contract is to cut off legal challenges about the formation of a contract. So it becomes much more difficult to claim, for example, that you signed a contract under duress if you have a provision in the contract that says you had an opportunity to review the contract with an attorney. I always use these provisions. For example, if I'm being put to a very quick deadline, I will actually use these provisions to say, hey, you're asking me to sign something right here and now, but the contract says that I have had the opportunity to review it with an attorney. So give me 72 hours to actually be able to review it with an attorney. With that, Jimmy and Sarah, I'm just going to generally ask both of you, do either of you, I know I've just hit a few pressure tactics, there's many more out there, but do either of you have any other, either hated pressure tactics or ones that you like to use against other parties when negotiating contracts?
Yeah, when you were when you were talking about the no time to consider it or review it, that it sort of reminds me that happens a lot when you get into litigation. So if you're talking about the job is going on, or if you're talking about maybe even before the job when you're negotiating the contract, that's one thing. But then let's say you're done the project, one of the subs files a mechanics lien or something on the project, and you're a general contractor. It might be the night before you have a court date and you get, a settlement agreement from the other side saying, hey, we're ready to settle this case. We just have to do it before our 9 a.m. Court call tomorrow morning or something like that. Well, you're giving this to me at 6 p.m. the night before. This is going to take a little bit more time. So in those situations, you have to wonder, why are you getting it now at the last second? If you've worked with the other side before, maybe you've developed that kind of rapport where you can say, hey, my apologies, I'm getting it to you late. I know, let's try and get on the phone in the next hour and work through some problems and we can get this done. Or let's move the court date a week and see if the judge will agree to do that so we have time to look at this. But that happens all the time, where you thought you agreed on something or what have you, and then you're on the courthouse steps and the other side will come in and say, oh, by the way, I need your client just to sign one more little piece of paper, and it's a pretty significant one. So that can also be an area or a situation when pressure tactics, specific time, tend to pop up. Sarah, I'm sure you've dealt with that in your prior litigation career.
Man, I had to stop myself from shaking my head so much. Yes, that resonates a lot with my experience with litigation. When Mike was talking earlier, one thing that really came to mind for me was how I've dealt with those situations when somebody's applying those pressure tactics. And for me, I tend to try and humanize the situation, being like, listen, I'm just one person. Maybe my client isn't available in the next 72 hours. Maybe I know it was just spring break. And so maybe they were out with their kids on spring break somewhere. They'll be back next week. Trying to give details surrounding why I need more time. For me, that's been more successful in trying to get additional time to review and approve documents. So, because everybody can relate to it, we're all human. So that's a tactic that I've used to counter some pressure tactics.
Absolutely. Yeah, and I'm always surprised at how even, and I've been an attorney now for 14 years, how I'll be caught off guard by a pressure tactic like this. I was negotiating a lease of an apartment a year ago for a small stretch of time, and the lady said to me, "We don't negotiate. You just have to sign the form." And I almost signed it. I was like, "Well, wait a second, I need to review this," and they let me edit a few things out, but I almost just took the bait and was like, "Okay, I'll just sign it as is. You said that you're not allowed to edit anything, so it can catch even people who negotiate contracts on a daily basis." Jimmy, I think I'm turning it over to you to talk about broad form indemnity.
Oh man, so much more exciting and so much more of a crowd pleaser than what you talked about. So yeah, I'm going to talk about indemnities, and specifically broad form indemnities. So to talk about it, first we need to understand what an indemnity clause is. So the sort of legalistic definition is the requirement of one party, known as the indemnitor, covering the costs generally of another party, the indemnity, in the event of a dispute. Well, let's put that into human terms. So what that means is that if we're on a construction project, and let's say I am a subcontractor and Sarah, to my right, is the general contractor. What this means is that I might agree to indemnify Sarah in the event that somebody sues Sarah if I did something wrong, right? So I'm the mechanical sub, and the mechanical system doesn't work. So the owner says, we have a problem with this, and they sue Sarah to fix it. Well, Sarah can seek indemnity from me. And what that means is that I cover her costs. If we're going to have to pay the owner one day, I'm going to be responsible for that. I'm going to indemnify Sarah. I may agree to pay her legal expenses if that happens, et cetera. So in that case, I'm the indemnitor. Sarah would be the indemnity. And it's pretty typical, right? And you would think in that situation, if I did something wrong, I should pay for it, right? The owner might not sue me, they might sue Sarah, but I should be the one to bear that expense. And not all indemnification provisions are unfair. But there are certain circumstances that could be unfair on your project. And the most sort of common one that you'll see is what's known as a broad form indemnity, which is that first bullet point. And what that means is that you are indemnifying someone else for their negligence, for something they did. So in my little example just now, what that would mean is that Sarah did something wrong, even though I know Sarah never would. But let's say she did something wrong on the project. I'm still going to be responsible for indemnifying her. Well, that may not be very fair. I didn't do anything wrong in that situation, but yet I'm going to have to cover the costs of the dispute, maybe the legal fees or the expert fees or the damages if there's a judgment or something like that. And subcontractors usually will find this kind of broad form indemnity unfair because the way they see it, they shouldn't be responsible to indemnify the prime contractor, if the prime contractor is the one who's responsible for the loss. So that's sort of broad form indemnities, sole negligence, that sort of stuff is what you want to look out for. The next bullet point is uninsurable indemnity obligations, and this sort of dovetails nicely from what Mike was talking about a second ago, and finding a reasonable objection that, hey, you're asking me to agree to something that's not insurable. Well, some indemnity obligations are not insurable. Your insurance company may not agree in your insurance contract with them, your insurance agreement, your policy, they may not agree to cover the costs of a contractually assumed indemnity to somebody else, specifically when you're talking about legal fees or something like that. So the first thing I'll say about this bullet point is read your insurance policy. And if you don't understand your insurance policy because they're written in like quadruple negatives and no one understands them, then talk to an insurance expert about how your policy works and what's covered. So if the insured, if you're the insured in that situation, if you're responsible for indemnifying someone else for their negligence, that may not be covered by your insurance. So the interplay between your contract, specifically the indemnity clause, and your insurance policy is important here and something you need to look out for. Another thing to look out for, the third bullet point here, what are known as states' anti-indemnity statutes. And I have an example of one here on the next slide from Maryland, which is one of the states in which I used to practice. And the statute here on your screen, this is most of the relevant section. I'm just going to read the underlined portion, and that it sort of makes sense as a standalone sentence. So a covenant, promise, agreement, or understanding, so a contract, purporting to indemnify the promisee against liability caused by or resulting from the sole negligence of the promisee or indemnity is against public policy and is void and unenforceable. What that means is that in Maryland, you can't agree to indemnify somebody when they did something wrong for their sole negligence. If both of you did something wrong and there's a question like you sort of both messed up, then that might be permissible in Maryland. But if it's the sole negligence of somebody else, those kind of and this is an anti-indemnity statute is going to come into play and protect the indemnitor in this situation. This is relatively straightforward. I think about half of the states in the US have enacted some form of anti-indemnity statutes. The interesting question, though, is what happens next? So let's say you do agree to an indemnity clause is a broad form indemnity and you're indemnifying somebody for their sole negligence and you're in Maryland. What happens if that issue arises? That's something that you would need to talk to an attorney about in your state to understand, do you have an anti-indemnity statute? And if you happen to have a broad form indemnity in your construction contract, what happens? How does the anti-indemnity statute work? Does the entire contract get thrown out and it's as if you just had a handshake and you have to kind of figure it out from there? Does just this clause get stricken out of the contract because it's against public policy and then you have to go from there? Or does the court get to reword it and say, let's just pretend you had agreed or you had complied with the anti-indemnity statute? How does that work if something were to come up, and different states are going to handle that differently? And sort of the last thing here about broad form indemnities is the next slide talks about, it actually just quotes a long section from a leading construction law treatise, and the important part here is actually what I've highlighted on the next slide, which is the bottom half of this. And this is your public policy argument. So the sentence is, why should one who plays no role in the creation of laws be responsible for making good the costs incurred by another who was solely responsible for it? This has led to a number of courts and legislatures to reject such risk shifting provisions. And that's what we just talked about with Maryland. And this is the argument, right? If in my little example from before, if Sarah and I have agreed to a complete risk shifting, and I'm going to indemnify her even for her own negligence, that may lead her to engage in more risky behavior because she knows she's not going to have to pay for it. So that's the argument usually that's used, is to say it's known as moral hazard to some extent, legalese, to say that it's not appropriate to have that kind of risk shifting because it really distorts the incentives of the parties if you know you're going to be covered regardless of what you do. So go ahead and do whatever you want. So those are the things to kind of think about when we're talking about broad form indemnities. And before I hand it over to talk about LDs, which is another exciting topic, I do want to say, to plug the AIA contracts, if you're familiar with our documents, then you're probably familiar with the A201. It's kind of our flagship general conditions. Section 3.18 is the indemnification language, and that indemnification language has been vetted over decades and chiseled and reformed and reformatted and all of that to really make it as fair as possible. So if you're looking to say, well, how do I know if the indemnity clause in my contract is fair? One thing to do would be maybe to compare it against that and to kind of say, is it the kind of language that's in there or not? Or of course, you can always talk to a construction attorney in your state. And with that, I'll hand it over, I think, to Sarah maybe to talk about LDs, unless anyone wants to keep talking about indemnities, which are fascinating.
Jimmy, can I make?
Yeah, go right ahead, Mike.
I just want to make a quick point. What the point that you just raised, Jimmy, about what happens next, when it comes to, an anti-indemnity statute, is a really good argument for making sure that don't rely on that anti-indemnity statute. Don't even let it get into your contract. If you see something that is broad form indemnity in nature in your contract, strike it out. Because yes, you could technically rely on the anti-indemnity statute to save you from that obligation, but don't do it because you really don't know exactly where that leads. And also just, it occurs to me, two things that you touched on: indemnity and insurance are, I think, the two biggest reasons why construction attorneys are worth their weight in gold as far as reviewing contracts, because they're very confusing and they're very nuanced. So if you run into an indemnity provision that you don't understand, and they are written to be confusing, definitely talk to an attorney and have them review it, because they'll be able to pick through all of the little nuanced language and let you know if you're taking on risks that you might not see if you just read it yourself.
Mike or team, can you let us know what section that is? Indemnity.
Sure. It is 3.18 in the A201 2017 General Conditions document.
Thank you.
Mm-hmm.
All right, fasten your seatbelts because we're on for another exciting topic. This one I do enjoy. It's liquidated damages. So you want to be on the lookout before you sign any kind of contract, including a construction contract where they're commonly seen, whether your contract includes a liquidated damages provision, and if it does, what exactly is your risk exposure there? So I'll take a step back, and first we'll start out with the preliminary question. What exactly are liquidated damages? Well, they're a predetermined amount of damages that must be paid if the contract is breached by one of the parties. And in construction contracts, they're typically expressed as a fee per unit of time. And this is in relation typically to like a major milestone, substantial completion, final completion. Those are the two that, at least in my experience, I saw liquidated damages would begin to accrue at one of those two major milestones. But of course, the parties could agree to something different. So just to put this in context, for example, if a contractor misses the substantial completion date, liquidated damages in the amount that's agreed to in the contract would begin to accrue and continue to accrue for each day that substantial completion is not met. The purpose of these kinds of contractual provisions is to allow the parties to agree upfront on a fair and reasonable amount of damages that might be otherwise really difficult to prove. Damages are typically pretty tough to prove when you're in that litigation track, but these would be ones that are particularly speculative or just otherwise very difficult to calculate. When you do include a liquidated damages provision in your contract, I like to think that it benefits both parties because it defines the risk and it eliminates the need to spend time, money, resources down the line in dispute resolution to not only prove your entitlement to damages, but also prove what those actual damages are. When a liquidated damages provision is in your contract, you should also be on the lookout for how they are assessed. This is something I wish I knew in practice, and I know we have it on multiple resources on our website, that you want to make sure your contract specifies how a claim for liquidated damages is actually assessed against one of the parties. So for example, are they going to be withheld from progress payments when the project isn't yet complete? Or does the owner have to assert and recover liquidated damages from a contractor down the line? Is there some kind of notice provision? Is there some kind of pathway set out in the contract to actually assert a claim for LDs? We can go to the next slide. So continuing about this riveting topic of liquidated damages, when exactly are they enforceable? In typical attorney fashion, my answer to that is it depends. It always depends. And certainly it depends on your jurisdiction. But generally speaking, courts will hold a liquidated damages provision unenforceable when they act as a penalty to induce performance or if they punish a breaching party. Well, what exactly does this mean? So if you read some of the case law that interprets liquidated damages provisions, courts, when they evaluate the enforceability of it, will typically put themselves in the shoes of the parties at the time of contracting. And at the time of contracting, the court will ask, were the damages difficult to estimate in advance? Or at the time of contracting, were they difficult to estimate for the parties? And what exactly is difficult to estimate? We typically see this when there's like a multitude of factors that influence the damages, or maybe they fluctuate over time, or they're just inherently speculative. When I was thinking about this, like what are some inherently difficult to calculate damages? And I think of lost profits, construction loan interest, or maybe an owner's loss of use on the project if there are delays. So in my opinion, these are some of the damages that are inherently difficult to calculate. The next factor that courts will usually consider when they're determining the enforceability of one of these clauses is whether the liquidated damages amount that the parties agreed to in the contract reflects the estimated damages flowing from the breach. So if the LD's amount is just grossly disproportionate to the foreseeable harm, the provision might be considered unenforceable. But of course, that's very fact dependent on your case and the situation of the project. Mike and Jimmy, have you guys had any experience with LDs?
I've got a few follow-ups. So I used to include LDs in a lot of contracts back when I was practicing. And I'll say that, if you're a contractor and you see a contract that's given to you by an owner that has an LDs in it, it's going to stand out to you because there's going to be a number that you're going to be on the hook for if you miss a deadline. So it's kind of the opposite of indemnity. Indemnity is kind of written in a way that's confusing. LDs usually stand out as if they're in neon lights. I would say always question how that number is calculated, because from practice, I can tell you that more times than not, it's just an attorney putting in a random number. And it shouldn't be, but that's usually how it works. So if you're a contractor and you see a number in LDs, question, well, where did you come up with that? What kind of loss are you concerned with? What kind of delay damages are you worried about? And you can probably negotiate back from there, or even negotiate something else like perhaps loss of use insurance instead of liquidated damages. And certainly, although as Sarah mentioned, I agree, it's certainly possible that LDs might not be enforceable if they are not, an actual estimate or a reasonable estimate of damages, forecast of damages. I wouldn't count on that. Make sure that you don't want to be in a position of owing hundreds of thousands of dollars in liquidated damages and making that argument that, oh, this is, unenforceable for some reason. That's going to be a tough argument to make, and you don't want to be in that position. So it's best to kind of cut those things out, or to get a reasonable amount of LDs, at the time of contracting, rather than fighting it, a year later when you got some attorneys writing you a letter saying that you owe them for LDs after you've missed a deadline. Jimmy, you got any thoughts?
Yeah, when I think of LDs, I always think of two examples, and they are stadiums and universities. Stadiums usually have a substantial completion date, like, football stadium, for example, is relatively easy. Like, you need to be done and substantially complete before kickoff of the first preseason game, because that stadium is going to generate a whole lot of revenue that first day. But then the team might have an away game the following week, so they don't get back for 2 weeks. So your LD is really that first day, and then there's no real, tangible loss for the 13 days, in addition to like your construction loans and interest and that sort of thing. But it's that first hurdle that you need to get over. But it just really sets a high deadline. So the LDs on those kinds of projects are usually very high. And then I also usually think of like universities when you're doing a dormitory, sort of around that mid to late summer timeline. That dormitory needs to be done so that students can move into it. And the parties might agree at the start of that construction project to say, well, our costs of not being done in time are incredibly high because we are going to have to house and relocate, 2,500 students in, the surrounding neighborhood for an extra month or two while you finish up. And we have no way of knowing exactly what that's going to cost, but we know it's going to be a lot. So the way we calculated LDs, to go back to Mike's point of, kind of figuring out how to calculate it, would be something like, well, what's the average rent for a 2-bedroom apartment in this neighborhood over the course of 2 months? And that's going to be, break that down in a per diem, and that's our LDs per day or something like that. That's kind of how we calculate it. It's to have a justifiable reason for it, knowing that that's the likely impact going to be if you missed your deadline.
All right, are we ready for the next, one? All right, I'm going to do a really quick one, and it's about waivers. And this is, you just need to be, anytime you are waiving rights by signing a contract, you need to be scrutinizing those waivers very closely. I should make a point here that not all waivers are unfair, obviously, right? So for example, waivers that are mutual, by that I mean when both parties are mutually waiving a particular right, they're more likely to be fair than if a waiver that only disadvantages one party. So for example, if you're familiar with AIA Contract Documents, you may know that our standard owner-contractor agreements typically contain a waiver of subrogation and a waiver of consequential damages. And there's nothing at all wrong with those kinds of waivers because they are mutual waivers. They do serve very specific kinds of purposes, which we won't get into on this. Those are kind of topics for another webinar. But there are plenty of waivers in contracts that you should be looking at skeptically. I mean, you should even look at the waiver of consequential damages skeptically to see exactly what kinds of rights you're waiving. But one that's a good, for example, is anything that attempts to waive, if you're a contractor, your rights to file a lien or to make a demand on a payment bond. Those should be reviewed very closely, stricken out in most instances. Lien rights have been around for hundreds of years. They're really a contractor's best, way to get paid. On public projects, you're, obviously not going to be able to have lien rights typically, but you will always have a payment bond that's in place instead. And there's, also statutes that will nullify attempts to waive liens, just like we've mentioned with anti-indemnity. And there are some statutory protections that I'll get to on the next slide. But just generally speaking, and this is again very general, look at the laws of your state when it comes to liens and lien rights. But if you are waiving a lien right as a condition of getting paid, for your work, and you've actually gotten paid, well, there's nothing wrong with that. And if you're waiving your lien rights when it comes to, about to make a claim on a payment bond, if you've already gotten paid, there's nothing wrong with that. But if you're signing a contract that preemptively waives your lien rights, again, a statute in your state may save you from that mistake in your contract, but don't make the mistake, cross it out. So don't waive your rights to liens, to make a lien claim before you've gotten paid. Certainly not preemptively in your contract. So scrutinize those kinds of things very closely. And I also just want to show you, this is an example from Georgia of a statute that, effectively one of these statutes that says that lien rights can't be waived in advance of furnishing labor. Sarah, right before we started this webinar, you informed me, thank you for informing me that this statute is now out of date. So this is just, keep in mind, this is an example, but every state has, some laws on the books with regards to mechanics liens and, exactly how the path you have to follow to perfect a mechanics lien, and also, what kind of rights you can waive. So just obviously make sure that you're understanding the laws of your state. My guess is that this whole idea of not being able to waive lien rights in advance of furnishing labor is still probably in that Georgia statute, but become familiar with the laws of your state when it comes to anything like this. And as always, look at any waivers very skeptically, particularly ones that only affect you. So next. By the way, I should say, Sarah, I mentioned you on that, but do you have any follow-up on that? I know you are a mechanics lien guru. So did I mess anything up there?
I will clarify. I'm actually not sure if it's out of date. In fact, that looked pretty up to date to me, but of course you should check and make sure you're familiar with your state laws. Don't rely on these slides for that. I would also like to add that sometimes contractors might have a standardized lien waiver form that they use on all of their contracts, but there are quite a few states that have their own standardized form that must be used. I'm not saying that a form that runs afoul to that statutory form would be found to be unenforceable, but you want to make sure that you're signing something that would be held up in court if it's ever contested. So even though you might be a contractor from Texas, if you're doing a project in Florida and There's a lien waiver that's attached to the subcontract that you're going to have to provide with every progress payment or your final payment. You want to make sure that that lien waiver doesn't run afoul to any requirements that are set out by the Florida legislature for lien waiver forms.
And we also should note that AIA Contract Documents does publish lien waiver forms. So that's relatively new in our library. So if you want to look at forms that AIA Contract Documents is published, go to our website. Jimmy?
Yeah, so let's talk about pay if paid versus pay when paid clauses. It's at first blush, they kind of seem like they're the same thing, but they're not. And I'll explain a little bit about what the difference is and why you kind of want to look for one versus the other one. So pay if paid basically says that what that first bullet point says, which is if I don't get paid, you don't get paid. It's like what we learned in grammar school is like an if-then statement. Like if I don't get paid, then you don't get paid, period. What that does is it shifts the risk of non-payment downstream to the subcontractor. Usually this is a contractor to a subcontractor relationship. So what the contractor is saying, the general contractor is saying, is that if I don't get paid, subcontractor, by the owner, Mr. or Mrs. Subcontractor, you're also not getting paid, period. It's what's referred to as a condition precedent. And it sometimes is referred to and analyzed as a reverse force majeure. It took me a while to kind of understand this, but with everything that's happened with COVID over the last couple of years, raise your hand if you were on a project that got affected during COVID. I'm sure everyone's hand on this webinar is going up right now. You probably are familiar with the term force majeure, right? Like you have, as a contractor or sub, if something happens to you, if you're a material supplier, and all of a sudden you were looking at a 2-week lead item and all of a sudden now it's a 4-month lead item, that risk through your force majeure language is going to get shifted upstream. The owner is eventually going to absorb that and either excuse the delay or maybe give you damages or something like that. This is sort of the reverse of that. So this is a risk that happens upstream that eventually makes its way downstream. Pay if paid clauses are not enforceable in every state, so you want to be a little bit wary of those. Paid when paid is slightly different, and it says, when I get paid, you will get paid. And other than just simply being more optimistic than the first pay if paid clause, it is legally very different. And here's why. Because what a court is going to say when it reads pay when paid is that only affects the timing of payment, 7 days, 14 days, whatever. It doesn't affect the ultimate right to payment. So who is absorbing the right or the risk of non-payment? It's the general contractor if it's a pay when paid, because even if your pay when paid clause doesn't say it, what a court is usually going to read into that is, comma, but after a reasonable period of time, comma, the contractor must make payment to the sub, even if they have not yet been paid. And that's the big difference, is that if it's pay if paid, there's a period hard stop. If I don't get paid, you don't get paid, period. If it's paid when paid, which usually they're structured in a way that says within 7 days of receipt of payment by the owner, the contractor will pay the subcontractor all sums due, or something like that. How that phrase is usually handled is, but if the owner never makes payment, the contractor still has to make payment after a reasonable period of time. And so the risk of loss, if no payment ever comes through in a pay when paid scenario, is the contractor. It's the upstream party. If paid, it's the downstream party. So if you have this kind of language in your contract, it's again something else you want to evaluate to make sure that it's fair for your particular project. Again, it's not necessarily unfair to have pay if paid. It's viewed a little bit less favorably, but if you have a really great relationship with the owner and it's an incredibly solvent entity, maybe this isn't a really big risk for you because this owner is going to make payments. They do it all the time. This isn't a big deal. But maybe if it's an owner you've never worked with before, or general contract you never worked with before, that's when you want to scrutinize this a little bit more. And that's it. We can move on to T for C's.
Something I want to add to what Jimmy was just saying, which Jimmy, you did a phenomenal job covering that, it is an ever-changing body of law. It just seems like throughout the unit, there is such a split depending on the states, how they interpret the enforceability of pay if paid or pay when paid. So that's something that you need to keep in mind, that it depends on your jurisdiction for those kinds of clauses. All right, moving on to our next topic, which is termination for convenience clauses. And these clauses provide the parties an option to terminate the contract for any reason, and what's really notable is without any cause. So by including this kind of clause in your contract, you might be able to avoid claims for improper termination, mostly because nobody has to screw up in order for an owner to cancel its general contractor, or terminate the contract, I should say. They can do it for whatever reason. Maybe it has to do with funding, maybe they're just having a bad day. Whatever it is, this clause allows you to cancel that contract for whatever reason. I say that all with a caveat, though, that a termination for convenience clause has to be exercised in good faith, because no matter where you are, every contract is subject to, or implied in every contract, I should say, is the, it must be, oh gosh, sorry, I'm getting all mixed up here. Implied in every contract is a covenant of good faith and fair dealing. So if the termination for convenience clause is exercised in bad faith, it might actually be considered a breach of contract. And so I can't say I ever saw this particular situation, but I like to demonstrate things with an example. So for example, if an owner terminates a contractor when the work is, let's say, like 90% complete, and the reasoning behind this termination is because the owner doesn't want to pay the profit to the contractor, even though there's just a little bit of work left, it might be considered a bad faith reason for terminating, for exercising the termination for convenience clause. If you do have a termination for convenience clause in your contract, you might also want to consider adding in provisions that specify payment to the contractor for work that's properly performed and any costs that the contractor might incur as a result of the termination. You can see on your slide on the screen, I pulled up some language from our A201 just to demonstrate what a termination for convenience clause might look like. And you can see in the highlighted portions that the owner may at any time terminate the contract for the owner's convenience and without any clause. And then you can also see under section 14.4.3 that if the contract is terminated, the owner must pay the contractor for work that's properly executed and costs incurred by reason of the termination. You can go on to the next slide, which I think is very related, which is
Sarah,
this, yeah.
Before we move on, can I just kind of chime in with one quick thing?
Absolutely.
Termination for convenience. I was sort of thinking back when you were talking about termination for convenience that usually there's also a clause in construction contracts that talks about a termination for default, which, you know, like you were saying, if the general contractor, for example, has done something wrong, they're not doing their job or what have you, they can get terminated for default. And a lot of times those two contracts are negotiated in tandem. And what most of the time the parties will agree on is say, well, the owner can terminate the contractor for default, and they have to follow like a really specific set of procedures to do that. But if for some reason they mess up and they don't follow the procedures, they don't give notice like within the timeline or something, then that termination will automatically convert into a termination for convenience. And I remember I was in a litigation dealing with this exact issue once where the client was a subcontractor who had been terminated allegedly for default. And we sort of had to convince them that their damages weren't maybe as high as they thought they were going to be, because what would happen is the court would just kind of convert it to a termination for convenience. So we'd have to look at that clause, even though the owner was saying they were terminating them for default. They didn't follow the steps exactly right, and that was like the whole argument. But at the end of the day, the court's just going to say, all right, fine, you messed up, but we'll just look at it as if it was a T for C, termination for convenience, and then what would have happened. So I was just sort of thinking about that as you were talking. So thank you for indulging me.
Yeah, that's a great point, and all the more reason to make sure one of those clauses is included in your contract. No matter the default, I will say, and that's why I think that assignment of subcontracts is a related issue, because if for whatever reason, if termination does occur on a project, you want to make sure that you have one of these assignment of subcontract clauses in your contract as well. And the purpose behind these types of clauses is to bridge contractual privity between typically the owner and subcontractors on the project. So if termination does occur, then the owner essentially can step into the shoes of the general contractor in the contractual sense and continue certain subcontractors' work on the project and just minimize those effects of termination. And again, I pulled up some language from our A201 document. Section 5.4 goes into detail about assignment of subcontracts. And for each under the A201, for each subcontract that is assigned by the contractor to the owner, provided that the termination occurs in accordance with the contract, when the owner accepts assignment of any subcontract, the owner assumes the contractor's rights and obligations under the subcontract. So nobody likes to think of it, but you always want to think about worst case scenario when you're entering into one of these contracts. What happens if termination or default does occur? How can you minimize those effects? Mike or Jimmy, do you have any experience with this?
I actually don't have too much experience with assignment of subcontracts, not in this context. When we're talking about like when bonds come involved, like sureties step in and they want to take over and assign contracts that way, I have a little bit more experience with that, but I actually don't. I was listening and learning as you were talking.
Hey, great. Well said.
Thanks, guys. Well, we can go on to the next slide. And this is sort of my catch-all slide. I think when we are talking about things to look for before you're entering into a construction contract, we would be remiss if we didn't talk about having a well-defined scope of work. I don't think we can say it enough times that each party's scope of work should be clearly defined. Everybody should be on the same page about what completed work looks like. What exactly is the owner paying for? One of the reasons you want to do this and have a well-defined scope of work is to align the expectations of the parties and then set boundaries about what constitutes completed work and what actually requires extra time and money. This protects all the parties. It gets everybody on the same page about what is actually expected of the contractor or a subcontractor. So we can't say it enough, but please make sure that all the parties' goals, deadlines, and deliverables of the work are set forth clearly in the contract.
Good point, Sarah. It actually reminds me of, I mean, obviously, like when you're a contractor, most of the time your scope of work is going to be set forth in drawings and specifications, right? I actually lived in a condo in Washington, D.C., where our board approved, to my objection, our board approved $250,000 worth of work to a contractor with no drawings and specifications. Literally a paragraph of text describing what this contractor was going to do. Shore up some, walls, do a little bit of work, but there was just no depth, and I remember making the argument, well, this contractor could, or very conceivably, fulfill their scope of work in like half a day's worth of work, because there's no concreteness to the actual scope of work. For some reason, that argument did not win the day, but yes, it goes for architect scope of work and for contractors as well. Have a well-defined scope of work before you're signing someone up to a contract, so that everyone's on the same page.
Yeah, you never want to walk away from a contract being like, what did I just pay for? I have no idea what I just paid for.
Oh, absolutely. Yeah. All right, I think we're ready for, we got a few more minutes left, and we've got honorable mentions, a handful of them. I'm just going to do these in rapid fire. They didn't make the top, 7 or 8, but these are things that, I think are still pretty interesting and worth talking about. One of the most common things that I've noticed, it's a bit of a pet peeve of mine, and I know I'm an outlier on that because it's not a huge issue usually to resolve in a negotiation, but it's when you've got projects in California, everyone has an office in California, and for some reason the contract says disputes are going to be resolved in the state of New York, or New York is going to apply to the contract that the parties are signing, New York state law. Now there's probably a lot of reasons for that. I mean, it might be that the headquarters of the companies in New York that that wrote the contract. It might be that the general counsel for the company that wrote the contract is just more familiar with New York state law. But push back on that. It really should be the place where the project is located is where your forum for dispute resolution and the choice of law provisions should be. Every time that I have raised this as an issue in the contract negotiation process, the parties are very easy to just, okay, we'll just change it to California or wherever the project is located. But this is usually not a big sticking point, but it comes up often, and a lot of times people will just sign the thing even though it's a very inconvenient to resolve disputes in another state. And you only run into it when you actually have a dispute. So pay attention to that. Know that you can usually get that changed fairly quickly. Length of contract, you'll hear a lot of people say, architects, contractors, I don't want to sign a long contract because a long contract is very likely to have things in there that are bad for me. And there's, to some degree that's true. It really just depends on who wrote the contract, right? I would suggest that the length of the contract is not really the problem, is the words within the contract that are a problem. So for example, our A201 general conditions document is one that, generally speaking, is fair to all parties. And most contractors, owners, and architects will, they'll probably have their own little picadillos with like A201 and some things that are in it, but generally speaking, people will, in the industry realize that that's a pretty fair document. But it's a long document. On the other hand, when I used to represent owners many years ago, the psychology of contractors and general contractors, and just anyone who's looking at a contract for the first time, less pages probably means it's okay, right? Well, I put together so many 1 or 2 page contracts that highly shifted risk, away from my company, the company that I was representing, but it's just 1 page. So it seemed a little bit more innocent. So read the contract, know that the words matter. The page count doesn't really matter all that much, so keep that in mind. And another thing to think about is that if you're looking at a contract where all the waivers, all the disclaimers, and all the indemnity provisions are directed at you're waiving all the rights, all the disclaimers are benefiting the other party, you're probably looking at a very one-sided agreement. Jimmy, I think you've got a handful here for contractors.
Sure. Yeah, sure. So I know we're running up on our time, so I'm just going to focus on one of these. And when you get the slides, you can take a look at the other ones, but I'm going to zoom in on number 2, which is the contract with inconsistent contract time provisions. And what do we mean by that? What I mean by that is this, and this comes from a specific experience that I had, and that is when your contract time is measured in days, so 365 days, you have a year, 365 days to get to substantial completion, but you also have milestones, and those milestones are measured in dates. So you have until July 4th to get to milestone 1, and then you have until September 8th to get to milestone 2. That's not necessarily unfair, but it could lead to an issue if you run into something here in the first couple of weeks of this project, and the owner says, you say, we're going to need more time. The owner says, yeah, fine, I'll give you an extra 5 days towards substantial completion. And you're like, great, sounds good. Well, then you're approaching July 4th and you're thinking, well, wait a minute, that milestone never changed. It was just you got an extra couple of days a year from now, but that's not going to help you out very much if you missed that first milestone. So you can think about how the terms of your contract, and specifically those related to time, are all going to talk to each other. And that's all I have to say about that.
Right. Well, we are at the end of our hour, or pretty much, but I'll just say that there's, for owners, don't, with few exception, don't prepay the contractor a ton. Also, if the contractor is waiving typical warranty obligations, just know that, there are some very standard warranty obligations in our A201, Section 3.5. Article 12 has them, I believe. Just don't waive those things without knowing what you're waiving. And if you're a novice owner, if you have not been in the construction, not negotiated a lot of construction contracts, or you're not very savvy about the construction process, be wary of cutting out the architect from the process, right? The architect during construction is going to be the entity who reviews your payment applications, who's going to be your eyes and ears on the site when they do site visits. Is going to, have a handful of obligations during construction that are going to be very beneficial to you as an owner. So don't cut them out of the process unless you know what you're doing, unless you have a real reason for doing that. So that is it. I wish we had time for questions, but we are right at 3 o'clock. Send us if you're seeing this on YouTube, put questions in the comment section. We'll be sure to try and respond to those. And we'll be sure to, respond to emails as well. I'll give you our if you have other questions for us, from a content perspective, go to docinfo@AIAcontracts.com. If you have questions about our tech support when you're actually negotiating contracts, support@AIAcontracts.com. And we have a learn page on our AIA Contracts website that has a ton of videos, articles, and other kinds of resources. So I want to say thank you to anyone who's listening to this. I really appreciate you sticking with us for the whole hour. Thank you, Sarah and Jimmy, for having this. I think this is one of the more fun programs that we've now done it twice, and I always think it's fun. I always learn something too. So thank you both.
Thanks, Mike. Same here.
Yeah, thanks, Mike, and thank you, everyone.